on the sitting, the first sitting of 19th September 2017, the Right Honourable Deputy Speaker assured the House that there was no be surprise to members of Parliament as far as handling constitutional amendment bills was concerned, because there was a lot of anxiety, and at that time the bill was not presented before Parliament. And on 20th, he repeated the same thing and assured members that nothing will be done in secrecy. You'll find that in the Hansard of 19th, which is annexed to the affidavit as C, and the Hansard of 20th, which is annexed as D. And my Lord, he clearly states that the rules of procedure are very clear, that all business has to go through the business committee under Rule 174. And in paragraph 14, Honorable Semuju deposes that he is a member of this committee by virtue of his position as the as the chief whip, and at no one moment was he ever invited to a meeting where that bill was to be put on the order paper. My Lord, members were taken to a surprise on the 26th day of September 2017, that is in paragraph 15, when the Right Honourable Speaker amended the order paper and on the floor of the House to allow Honourable Majesty to bring the bill. In paragraph 17, efforts were made by Honourable the Shadow Minister of Justice and Constitutional Affairs, Honourable Meda Disegona M. Pibusiro, is to bring it to the attention of the Speaker that there were other motions which had preceded this one, particularly the one which had been brought by Honourable Patrick Nsamba. It is clearly stated there, but all this was ignored. My Lord, in Rule 29, the Rule 28 of the Rules of Procedure, it is clearly stated that the Speaker and the Clerk of Parliament are enjoined to give the order paper. In case of the first sitting, that is Rule 27, order paper. In the case of the first sitting, it has to be at least 2 days before the sitting. In any other case, at least 3 hours before the sitting. And in Rule 29, my Lord, there must be a weekly order paper, including relevant documents that shall be distributed to every member through his pigeonhole, and where possible, electronically. This was never the case. My Lord, this amendment, in my opinion, is the way the bill was introduced was worse than the one that happened in 1966, the so-called pigeonhole constitution. Because at least the pigeonhole constitution was placed in the pigeonhole of members. But this one was never placed there. It came as a surprise on that very day when the Speaker...
Councillor, the pigeonhole constitution was first approved without all the so many members of Parliament ever setting their eyes on it. I'm sure you know this. Are you saying this was smuggled as an item for discussion, but it was never discussed and it was passed without discussion?
The pigeonhole?
The pigeonhole constitution was not debated by Parliament before approving. Actually, they were told, as you are getting out, you will find it in your pigeonholes. They had already approved it.
My Lord, I'll demonstrate to you that the difference was...
It should actually be in the Guinness Book of Records.
My Lord, even in this particular case, I will demonstrate to you by the end of my submission that even this debate was cosmetic. There was no debate at all.
Okay.
Most obliged, my Lord. My Lord, as I wind up on that particular point, that particular incident, there is corroborative evidence in paragraph 16 of Honorable Jonathan Odul, paragraph 12 of Honorable Alan Sewanyana's affidavit, paragraph 11 on Honorable Karuhanga's affidavit, and paragraph 10, 11, and 12 of Honorable Mubarak Munyagwa's affidavit. My Lord, this particular incident took members by surprise and overwhelmed everyone in the country. My Lord, I will move on to the second instance, that is the illegal suspension of the members of Parliament. And this one is pleaded in paragraph 15G, and the evidence is to be found in the affidavit of Honorable Semuju Nganda, paragraph 28, 29, 30, 31. Munyagwa's affidavit, paragraph 16, Roman N, O, P, Q, R, and S. And Honorable Dul's affidavit, paragraph 16. And it is also dependent to, even, my Lord, this fact was admitted by the clerk of Parliament in cross-examination here, that the members were suspended without being given an opportunity to be heard. That's on record. That's what she said, and said the rules will not provide for that. My Lord, I invite you to find that that statement has no place in our jurisprudence, that a person can be condemned unheard. It's a well-known principle that at a party should be heard before condemned. My Lord, Annexure D to Chibirige's affidavit, in page 15, my Lord, Chibirige, that affidavit, that brings out the fact, my Lord, of what actually transpired on that day. My Lord, I would like to draw your attention to what the Speaker said, which is very important. It is page 15 of the Hansard. The Speaker said, Honorable members, I have made my ruling on that issue. There was a preceding issue. I will ascertain the issue which has been raised about membership and that committee, particularly the number of members. I also would like to check the Daily Hansard because I was not here when the transfers were made. Therefore, I will suspend the proceedings for today up to 2 p.m. I suspend the proceedings up to 2 o'clock. But in the meantime, the following members are suspended: Honorable Ibrahim Semuju Nganda, Honorable Alan Sewanyana, Honorable Gerard Karuhanga, Honorable Jonathan Odul, Honorable Mbaraka Munyagwa, Honorable Anthony Akol. They should not come back in the afternoon. Applause. My Lord,
this is answered of when?
My Lord, this is the Hansard of 18th December 2017, page 15. My Lord, you can clearly see, at that particular moment, even the Speaker was already factors official. She had exhausted the powers. Parliament had been suspended. It's like you have adjourned the court here and then you issue orders throwing Ilukwaga out of court. When you have said sittings, the court proceedings are adjourned. So the Speaker said Parliament is suspended to 2 p.m. But in the meantime, the following members are suspended. You cannot, these are honorable members of Parliament representing the people of Uganda. 6 members of Parliament with constituencies, and you just dismiss them casually like that. My Lord, that should not be accepted in any given democracy. On that particular point, my Lord, our authorities are there. The authority, the number 5 in our bundle of authorities, the volume 1, and also, my Lord, in volume 2, the first decision, the locus classicus on the doctrine of basic structure. On page 92, my Lord, they made a very interesting finding here on the right to fair hearing, which I would wish to draw your attention to. Indeed, their judicial dicta to the effect that God himself considered himself bound by those elementary principles of natural justice, whose love was planted in man by him. They quoted an authority and they said that they decided as follows: the laws of God and man both give the party an opportunity to make his defense, if he has any. I remember to have heard and observed by a very learned man upon such an occasion that even God himself did not pass sentence upon Adam before he called him up to give his defense. Adam, God says, Where are you? Has thou not eaten of the tree whereof I commanded thee, thou you shouldn't not eat? And the same question was put to Eve. My Lord, this is a Supreme Court decision of India, where they are quoting the law of that even God himself, before condemning Adam and Eve.
Is that in the Bible or in the Quran?
Councillor Poago.
My Lord.
Learned Councillor Poago.
Yes, my Lord.
That authority, I think you can find it in Wade in administrative law, citing an early English authority. My concern is, it's true, God in Genesis, I forgot the verse, but it's in Genesis, the fall of man. God gave Adam a hearing, gave Eve a hearing. But there were three parties in the commission of that crime. God did not give the serpent a hearing. So when it came to the serpent, just condemned him to... I believe the Quran says the same thing. I've read the Torah, I've read the Bible, I've read the Quran.
My Lord, I'll leave that to you to decide, since I'm racing against the time. My Lord, the other incident is suspension of Rule 2012. Upon presentation of the report, I'll be very brief. Petition in paragraph 15, it is pleaded. The annexure D, that is the affidavit of Chibirike. There is, my Lord, on page 452, the Deputy Attorney General, this is the answer, where when the report was presented, the Deputy Attorney General, Mr. Mwesugwarukutana, saying, Madam Speaker, I beg to move a motion under Rule 16 of our Rules of Procedure to have Rule 202 suspended so that the debate on the motion can begin immediately. The grounds for my motion are that, first of all, this sub-rule is intended to ensure that honorable members have notice of the report. My Lords, the right Deputy Attorney General recognized the full import, the importance, the significance of that rule to give members of notice. And there was earlier on contention on page 11, my Lord, where Honorable Alan Sewanyana had raised to the Speaker the issue of the report not being tabled by the chairperson of the committee. It was never laid on table as required under the rules. And this, my Lord, is the chairperson just said it is just electronically downloaded, and that is not what was provided for here. So they recognized that. So unfortunately, my Lord, if you read page 51 of that hazard, they went ahead, a resolution was made to suspend the rules, and each member was given only 3 minutes within which to make their submission. Only 3 minutes. The report is just given on that day. Members are saying, look here, we do not have it. It has not been given to us manually. We don't have the hard copy. But they are saying, the rules be suspended, begin the debate now. You can see how Parliament was being stampeded in a matter of this gravity of this importance. Honorable Katuntu, you'll find that he warned them about this, but he was ignored. My Lord, I'll leave the rest to you on that particular issue, but that was a gross violation of the rule which required that members be given adequate time to scrutinize the report, make a meaningful contribution to the matter, the subject matter, given its significance that you are amending a very important document, that is the Constitution, and members are stampeded like that. 3 minutes. If you had given me only 3 minutes here, my Lord, I don't know how much I would do to convince you on this particular matter. My Lord, the second last...
I would just judge your demeanor and write my judgment.
My Lord, the second last matter, the second last is failure to close the doors to the chambers, contrary to Rule 98, Sub-Rule 4. My Lord, again, I would refer you to the Hansard. My Lord, the Hansard of 20th, when that bill was being debated and passed, And my Lord, particularly page 55269, you will see there as members, the first set of members after voting. You will see there is where the speaker comes out after, because Honorable Jacob Oranya, they indicated was absent, MP number 433. They said the right Honorable Speaker says, Honorable members, there were members who were called and were in the lobby. Clerk, please call them. And you see, my Lord, a whole list of 55 members who were called. Some, yes, were absent, but others came and reported. And my Lord, the rationale of this rule is to bar members who had not participated in the debate to come and vote. Because what are you voting on? You have not been party to the debate, and you come in. You are called at the time of voting. Now that is the mischief that was intended to be covered by that rule, but the Speaker left the doors wide open. That fact was admitted by the Clerk to Parliament in her affidavit, my Lord, which is on record.
I don't understand your point. Because I feel quite uncomfortable that the motion is about to be voted on, and the Speaker suspends people, and then they can't come back to vote. That's very dangerous. See, you have a situation where you have a parliament with a majority of one person or two. Now if the Speaker decides to send away 5 people just before the vote, and we are saying because they were not in, they should not vote, then that compounds the injustice. It compounds the injustice, because you've seen the U.S. Congress. 1 or 2 votes make a difference. So I also don't understand the legality. How can the Speaker suspend people when there is a debate that's not, the motion that's not being voted upon?
My Lord, yes, I understand that, but we are...
Proceed.
Most obliged, my Lord.
Uncomfortable. You say the ones in the rebel should not have been brought in to vote.
Those who were forcefully thrown out had the right to participate in the debate and voting. But these ones who voluntarily kept away and were being compelled to come back and vote, you can see, my Lord, the contradiction there. So that's the whole point I was making, and the rationale in that rule.
Council Quack, is it your submission that for a member of Parliament to vote on what is being deliberated upon, that member must have participated in debating?
Yes, my Lord, because you are representative of the people. Article 1 commands you to reflect the will of the people. You must participate in the debate and vote cautiously. You vote on issues which you understand.
Which rule is that?
My Lord, that very rule which excludes members who have not participated in the debate, which provides that once you go to the point of voting, please lock all the doors. Lock all the doors.
The rule says if you're at the lobby, then you're not participating. You
are out, my Lord. You are out of the chambers. So at the time of voting, once the Speaker makes a ruling that it's time for voting, under Rule 9084, lock all the doors.
You see, what we are saying, part for me, I'm saying, that's dangerous. Your line of argument is self-defeating and extremely dangerous, because people are going to be locked out deliberately or unintentionally or otherwise when the motion is being put to vote. And if we rule on that, tomorrow it will come to...
And Council, I find the other reason I find that argument dangerous. It's the fallacy that if you are within the chambers of Parliament, you can vote. Take this MP for something north or something east constituency. Immediately on arrival, falls dead asleep. When it comes to voting now, the neighbor nudges him or her, and then the person votes because it's inside. If you compare this person with the person who is in the lobby, actually following the debate.
On TV.
Yes, he's at the lobby, but following the debate. You're saying this should not vote, but the hero sleeper or can't vote.
No, my lord, the person is pretending over parliament.
In view of the fact that members of parliament are being asked to sleep, but wake up and vote.
My lord, in that case, the speaker would call them to order. You can actually be thrown out of the house.
No, the speaker may not have noticed. It's only the neighbor who says, it's now time for voting. And the person votes.
My lord, that would be an absurdity as well. But the rules...
Similarly, don't you think it would be absurd to bar somebody who's just next door, following the debate, maybe wants some fresh air, and seated at the lobby following the debate, and then goes to...
And how unjust it is for parties that have few members of parliament, or where the debate is, the vote is going to be closed. Very, very dangerous. For me, I think members of parliament should be able to vote from home, or even from a hospital bed. Yes, they are done.
But even then, the rules provide for ringing of the bell. You ring a bell, you ring it for those inside or even for those in the lobby.
Well, until it is amended, unfortunately, my lord,
yeah, but you are challenging the rules.
I appreciate, yes. I appreciate the concerns, my lord, but I was invoking the rule as is now.
Fine, proceed.
Lastly, my lord...
Council, you've taken 35,
I'm winding up.
35 minutes of the time allocated.
I pray for only 2 minutes.
And I took away 5 minutes because of the interventions, and otherwise you are technically, you've taken 40 minutes already. But I've taken away
Let me conclude with one incident.
As you conclude, my lord, that you are now doing this intervention, so
yes.
you are by 2 minutes. The legality of a rule that allows the speaker to suspend members and prevent them from voting as a result of that suspension. How legal is it? Because, you see, it can be straight. He can suspend 100 members.
No. Yeah, that's
yes.
Yes,
she can suspend 100 members and then put the motion to vote.
My lord, we are... In this particular case, the rule was abused in such a way that Rule 88...
I'm just talking about the rules of parliament that allow the speaker to suspend members, then continue and allow the remaining members to vote. That's one. The other is whether the police can intercept the member of parliament who is going to parliament to vote. Then what will happen?
My lord, I leave that to you to decide.
Yes, proceed.
My lord, lastly, we have submitted extensively on the inclusion of matters which were not canvassed in the bill, and the speaker entertained the same. I will not repeat all those ones. They are already on record, but it is pleaded in paragraph 15. I'll just cite one incident which you have not submitted on. My lord, I'll take you to the paragraph, to the Hansard of 20th December on page 5264, where the Right Honorable Kutana, Deputy Attorney General, warned the House. He rose on a point of order, and this is what he said. I rise on a point of procedure. We have passed the provisions of the Majesty Bill. I don't know why he called it the Majesty Bill. I rise on a point of procedure. We have passed the provisions of the Majesty Bill with amendments. We have also passed the amendment proposed by Honorable Tumusime, including term limits proposed by Honorable Nandala. However, there is something we have to clarify. Madam Speaker, in the Tusime amendments, the commencement date is clearly specified. However, in the Nandala Mafari amendment, we did not agree on the commencement date. Then the interjection. What is in the committee report is not what we passed. The chairperson abandoned the amendment in the committee report. Honorable Nandala Mafabi moved his own amendment. but it falls short of the commencement date. And yet in the SIMA amendment, there is the commencement date. Madam Speaker, if we are to move properly, we should be clear on the amendment date of the Nandala Mafari amendment. I would like to propose that it should be known to us that we do not have mandate to determine presidential terms. That is for the referendum. The commencement date for the term limits can only be after the referendum. My lords, when he cautioned them, no decision was taken in Parliament on this. But surprisingly, in the final product, they bring Section 9, amending Article 209A, to say that Clause 2 of Article 105 shall come into effect upon dissolution of the Parliament in existence at the commencement of this Act. My Lord, this provision was clearly smuggled in because it was never a resolution of Parliament here, and the Right Honourable Attorney General here moved to the House to consider that issue. It was never considered, only to surface in the final product. In a nutshell, my Lord, these are just a few instances of the transgressions of the rules of procedures and principles. There's a whole litany which I invite you to look at, which is a catalogue of which is given, my Lord, in our pleadings and evidence to show that Parliament violated the rules, violated the principles, they transgressed the values we have in enacting this Constitution beyond actual and ordinary act or bill of Parliament. And that cannot be acceptable in a situation where we are dealing with a constitutional amendment. I beg to submit that you be pleased on that account to nullify the Act as a product of, with due respect, of a fraudulent process. I beg to move. I thank you, my Lord.
Yes, Mr. Mbale, you have 30 minutes.
Thank you, my Lords. My Lords, I'm going to urge you all sub-issues in issue 7, except sub-issue, is it B or B? Except one. Except F. Except F.
Except?
F.
F.
Yes.
Meaning you are abandoning it?
No, it is not mine. I never pleaded it.
I think it was touched on by Councillor Kwame.
Yes. So, my Lords, the general principle underlying issue 7 is that Parliament must comply with its rules of procedure. And where it fails, that renders the entire process null and void. My Lord, this is derived from Article 94 of the Constitution, which says that Parliament may make rules, and when it makes them, it must comply. I'm relying on Roko Nyango and others, Pastor Attorney General. It is petition number 8, 2014. This court held that Parliament as a lawmaking body should set standards for compliance with the Constitution and provisions of its rules. The enactment of the law is a process, and if any of the stages therein is flawed, that's where my emphasis is. If any of the process therein is flawed, that vitiates the entire process and the law that is enacted as a result of it. My Lords, I submit that you are bound to follow this decision of this court, and I'm relying on the case of Semogere versus Attorney General, petition number 2. Therein, Odoki CJ was clear. He said at page 188 of my bundle A that as regards its own decisions, he means the Constitutional Court, it would normally be bound by them, except under the circumstances set out in Young versus Bristol. Those are known, the circumstances. So, my Lord, you being bound by your decision in Oroko Nyang, I submit that as we are going to show that there was flouting of the rules of procedure, that they vitiated the entire act. My Lord, I now move on to sub-issue A. My Lord, sub-issue A relates to chasing members of public from the gallery of Parliament. And this was a personal experience of mine. if you shall look at...
Is it chasing or preventing?
Preventing.
No.
But in that process, I was chased and threatened with an arrest.
No, your issue, the way it is framed, is about
Most of like.
preventing. Yeah.
My lords, if you look at my paragraph 39, 43, 47, 53 of my affidavit in support of the petition, it's clear that as a citizen in exercise of my rights under Article 38, I went to Parliament. I wasn't allowed there. My submission is that that was contrary to Rule 23 of the Rules of Parliament. My Lord, Rule 23 provides that proceedings of Parliament shall be public. And under Sub-Rule 2, it sets out a procedure. If you want to restrict them, there must be a motion, there must be a decision by the entire House that we are restricting the session. In this case, I've looked through the Hansard, there was no decision. But when I went there, I was prevented, I was almost arrested, I just ran away. My Lord, this is contrary to Article 79(3) of the Constitution and paragraph 2, Roman 1 of the Objective Principles, where this Parliament is obliged to promote democratic principles. And democracy is only accomplished when people participate in the processes. I move on, my Lord, to sub-issue B, C, and E. I'm going to argue them together. B, C, and E. All those issues, my lords, relate to the decision of to proceeding by Parliament in absence of opposition members. And my lord, I point out to you the answer that pages 4740, 4744, and then there is part of the answer attached to Ms. Chivide's affidavit, which is not numbered, but when you look at page 24 of Annex E to her affidavit, and page 37, you discover that actually members of the opposition were not in Parliament when most of the things were being carried out. Some had been suspended, others moved out voluntarily in protest. And my submission, my lords, is that Parliament as a body is not properly constituted in a multi-party system when the opposition is not in Parliament.
What do you say for the members who, according to you, moved out of their own motion?
The same, my lord, and I'm relying on local construction. There's a decision of the Supreme Court.
Should either the opposition or the members whose party is in government hold everybody at ransom?
My lords, if that happens, it's the duty of the Speaker and the whips to forge a way forward of how they shall proceed. And an example, my lord, is here.
When there is quorum, what should the Speaker do? For the ones who are suspended, I can understand your argument. How about those who choose now to walk out but still leaving quorum?
My lords, I'm going to give an example. And in the Constitution, we have two systems of governance: multipartism and movement. In 2000, we said we want movement. That will be okay. In 2005, we said we were going multi-party. And we amended the Constitution to accommodate multi-party politics. And the rules were also amended. And an example I'm giving here is this quote, my lord. If one of you moves out in protest, you can't proceed because you're not properly constituted. It doesn't mean that the majority don't matter. But once one of you is out...
No, this is a quorum established by law. It's a quorum.
My lord.
Similarly, when the quorum of Parliament falls below, that's why the first bill was put on referendum was annulled because it was passed without quorum.
My lord,
so you can find another example, but I don't think
for example, what will happen if the opposition win no seat in Parliament?
That will be a different situation. But in light of the following articles of the Constitution, I invite you to read Article 75. Article 75, together with Article 82, capital A, together 75, Article 82, capital A, Article 108, capital A.
Go ahead and make your...
is the argument I'm making. I'm now referring to the laws. And then the following provisions of the Administration of Parliament Act as amended in 2006. Section 6 capital E, Section 6 capital I, and Section 6 capital J. And then, my lords, I also invite you to read the following rules of procedure of Parliament. Rule 9. I'm going to explain their import. Rule 14 and Rule 15. Their import is that in a multi-party parliament, business can only proceed when all the sides are represented. Because they prescribe how we shall proceed, they prescribe who leads what, they prescribe who hates what. So when you read all those, you shall discover that in a multi-party system, and I emphasize that, Parliament cannot proceed in the absence of the opposition. Then it will not be properly constituted. And my lord, I was referring to the decision of local construction versus, it is Hamid versus local construction. It's Supreme Court Civil Appeal number 1, 2013. The land justices made a simple passage which I want to read briefly. They said, Mr. Tusime, Land Council for the respondent, submitted further that it's the majority who matter, and therefore that there was nothing wrong done here. We are here attempted to pose a question. If it is the majority who matter, why was it necessary for the Constitution to provide under Article 135 that the Court of Appeal shall be constituted at any sitting if it consists of an even number, not being less than 3 members? Participation in the hearing by an uneven number of members presupposes that the majority will carry the day, but every member must have participated in the hearing at all stages of the appeal. It may possibly be argued that the majority who participated in the hearing at all stages could disagree with the stranger to the hearing, but it can also be legitimately argued that the stranger could persuade the majority to his view. So my lord, don't undermine the presence of the opposition, because this is a debate. Someone may debate better, and then one of them may decide to go the other way. So my lord, it's my submission that when you look at all those, Parliament is not properly constituted when it has no opposition. And my submission, my lord, again is, the Speaker, having punished members for crossing the floor, she was stopped from directing the minority members to cross the floor casually, as she did. My lord, when you go to page 4738 of the Hansard, this Speaker, 4738 of the Hansard, this Speaker, among many things she said while suspending members, she said some members crossed from one side to the other in a menacing manner, contrary to Rule 74 of the Rules of Procedure. And she referred to Rule 82. She knew that crossing the floor is also unconstitutional, but even within the rules, you're not supposed to cross the floor. And my lords, she could not turn around at page 4743 of the Hansard to allow honorable members to cross, like saying, honorable members, come and sit this side. My lords, I'm relying on section 114 of the Evidence Act. I'm relying on Hamid versus local construction. That is Supreme Court Appeal number 14 of 2015. I'm relying on Manivan versus Mugarula for the proposition that actually the Speaker was stopped because she made it public that crossing the floor is improper, but then she allowed it to happen. And my lord, this action of allowing these members to cross the floor surely put the members at a risk of losing their seats and actually undermine the multi-party democracy. Why? Because under Article 83.1G and 83.1H of the Constitution, just crossing the floor is enough for you to lose your seat. And my lords, in Sechikubo versus Attorney General, the Supreme Court was clear that the purpose of those clauses is for the public to make MPs accountable. So just imagine someone voted an NRM member, is watching on TV, this member is sitting on the opposition side. Surely our people, the voters, and the general public may, if not well explained, may think that he crossed the floor. And my lords, I'm relying on the Malawi decision in the matter of a question of crossing the floor by members of parliament. It is at my index 203. But that court was clear that what matters is the wording of the constitutional provision relating to defection provisions. These must be construed in such a way that the clear intention of the legislature in enacting such provision is carried out. I've just submitted that the intention of the legislature was to make MPs accountable. So this casual way, go and sit there. You can occupy those seats. My lord, it's not in line with the Constitution. My lord, I now move on to issue 7D. My lord, 7D, I'm referring you to Rule 40 of the 10th Parliament Rules of Procedure, which provide that a bill shall only spend in a committee for 45 days. And after that, the leave of the entire House will be required. But my lords, contrary to that, at page 15 of Annexure E to the affidavit of Ms. Jane Chivirike, that's the answer. The Speaker was very clear. 6 members were added on the committee after those days had passed and after the committee had actually finished entertaining members of the public. So these members never had the people presenting their views. And these were Honorable Idi Amin, Honorable Kero Rose Lile, Honorable Akampulila Prose, Honorable Subi Brenda Sinde, Honorable Kamsime Caroline, and Honorable Kaso Robert Sebunya. And my lord, they signed the report after coming on the committee when the time had expired and without participating in any proceeding. And my lord, when you read Article 90, Sub-Article 3, Paragraph C of the Constitution, parliamentary committees have powers of the High Court. Under Article 90, Sub-Article 3, Paragraph C. Therefore, there is a presupposition by the Constitution that these committees must adhere to Articles 2081, 42, and 44C of the Constitution, because they have powers of the High Court. And my lord, I'm relying on the decision of Hamid versus local construction, Supreme Court number of 2013, where it was held that it is our opinion, in our opinion, it's improper and contrary to natural justice for a stranger to the hearing to decide and sign a purported judgment or ruling. In this case, my lord, instead of judgment, let's put there a report, because this report was a decision which was debated and later carried on. My lord, I move on to issue sub-issue D Roman 1. My lord, my submission here, I shall refer you to Rule 59.1 of the rules of the 10th Parliament. They are clear that no motion shall be moved except it has been seconded. So secondment of a motion, my lords, is an important segment in the procedure of Parliament. And my lord, Honorable Rukutana's motion was never seconded. Rukutana's motion to suspend the rules was never seconded. And at page 55 of Annexure E to Honorable Ms. Jane Chivirike's affidavit, Honorable Centenary warned the Speaker that are we in order if the motion has not been seconded? And my lords, he was clear, he said at page 56 that may I know who seconded the motion? Are we proceeding right? But the Speaker ignored him and said, please take your seat. Let us do some work. My lords, it's all about, at page 56 of the affidavit, page 56 of Annexure E. You see, Annexure E is unanswered, but not in the other normal form. So she just said, take your seats, let us do some work. It's my submission that in Parliament, it's not all about doing some work. It's about doing work in compliance with the Constitution and the rules. And my lord, this same Speaker, if you look at pages 4742 of the Hansard, 4790 of the Hansard, she was very clear on every motion which was being introduced. She was asking, is it seconded? is it seconded? And she would ask the names of people who were seconded. But then she turns out, and I reiterate that she was stopped from claiming that secondment is not a requirement. Yet at the Hansard in the same proceedings, she made it a requirement herself. My lords, it's my submission, and relying on Makula International versus Cardinal Subuga, that the failure to second the motion by the Honorable Lokutana to suspend the rules of Parliament rendered each and everything a nullity. Because in this court of law, you cannot sanction what is illegal. And at this time, we have pointed it out, my lords.
You have 15 minutes remaining?
15 minutes?
15.
Yes, they are enough for me, my lords. My lords, I shall now move on to 7G Roman 2. This is debating. Refusing, the speaker not allowing every member who wanted to debate. My lords, this same speaker, at page 4746 of the Hansard, had made it clear to members.
My Lord, just a clarification. I had
Yes.
my Lord, the executive just say 15 minutes. My Lord, I hope that does not include also.
No, it does not.
Obliged.
Yes.
Thank you, my lord. I was saying at page 400, at 4746 of the Hansard, the speaker put members on notice, and she said, as you proceed with the processing of the bill, I would like to remind you about the sovereignty of the people and Article 1 of the Constitution. The people are central to this issue. It's not an issue we can exclusively decide. We can decide exclusively without the population. In other issues, in my interpretation, this would mean a referendum. But here, how they were handling it, the clerk said she meant that you can't consult. But my lords, when you go to page 5226 of the Hansard, this same speaker was clear that actually only 124 members out of the 451 members had debated. And my lord, this translates to only 28.5%.
Is there a rule?
Out of how many?
Out of 451, it was the total. So when you remove the ex-officials and the one who was absent, the voting members were 434.
So which rule says everybody must speak in Parliament before
My lords,
the question is put?
my lords, because the speaker clearly put Article 1 in issue, and she was clear that this matter was a matter of the people, there is no way she could prevent these members from presenting the views of their people on the floor. Because this election voting precedes the debate. And it's in the debate where every member could say, I went and consulted and they told me this. And then she could not turn around and say, and my lord, look at the margin, the percentage. It is 28.5%.
She said, Mr. Mbale,
Respect of what?
of the members who have a right to vote. Of the 434 members with voting rights,
Yes.
only 124 debated.
124.
Yes.
Debated meaning spoke.
Yes, as in debating on the floor to say, my people told me, I do this, these are my reasons. And in those, there were some, like Tumukunde, who was an ex-official. So 28.5% is the only percentage which debated. On this matter,
are those the only ones who were allowed by the speaker to vote? Those who spoke.
As I shall be arguing at closing the doors, in Parliament it's not about voting. Actually, when I will come to closing the doors, I shall show you that the framers of the Commonwealth Rules of Parliament were clear that if a member is to vote, that member must have participated in the debate. For one purpose, you are making fundamental decisions. And my lords, when you look at Article 98, there are several modes of voting.
No, what is participation in the debate? What is your interpretation of participation in the debate?
My lords, in this case, when
Honorable Mobilizi, representing Kampala Central, makes a point, and me who have never spoken and will not speak, stamp my feet like this, Haven't I participating?
My lords, this issue is about debate.
That's the debate.
Yes.
Supporting another person.
But because you speak everything that I would have spoken, why should I stand up to speak again?
My lords, if you look at pages 5228.
I think the issue is whether a person who wants to debate is given an opportunity.
That's where I'm moving now.
It's different from the fact that everyone must debate. The question is, members of parliament who were present and wanted, were they all given an opportunity, or were some members denied an opportunity?
I'm moving there, my lord.
Then you go to the evidence.
That's where I'm moving.
That's the principle, I think.
Thank you, my lord. Page 5228. 5228 of the Hansard. 5228 to 5229 of the Hansard. Honorable Amongin, she's from Angola.
Wait,
She
yeah.
5228.
She's from where?
Angola.
Where?
Is it Angola?
Oh, Ngora.
Ngora.
In Teso.
Yes, in
It's
Teso.
Ngora.
Yes.
Not Ngora. It is Ngora. They will take offense if they hear you.
So, my lords, at that page, Honorable Bongin and Honorable Winfred Kiza, leader of opposition, were so clear that they wanted to debate, but the speaker overruled them. And then at page 5229, Honorable Tinka Simile was clear. And he told the speaker that we came here to legislate. We are not voting machines. So if you go by the element that's about voting, then we're turning MPs into voting machines. As if you just press a button and then it says yes, it says no. And my lord, the speaker ignored all this. And it's my submission that my lord vitiated this process. He tainted it so much that...
Okay.
My lord, I'm moving on, G Roman 3. I think that's my last part. On failure to close the doors before voting. My lord, central to this is Rule 98 of the Rules of Procedure of Parliament. My lord's Rule 98 specifies several modes of voting. It can be generally by saying aye. It can be by separate ballot. For example, at impeachment, it has to be separate. But it says, when it comes to a constitutional amendment, it must be by roll call and vote. It's called tally, roll call, tally, and vote. Roll call, tally, voting, that's the mode for a constitutional amendment. And then it specifies the rules of roll call and tally. So first, the speaker shall ring the bell, so that every member, whether you are in the lobby or where you come in.
Oh, so you agree that whoever is outside
can be called in, yes. Because
so, contrary to the submission by Learned Counsel Elias Kokwat.
I think he was agreeing with me. Because the principle was, they must be inside. And to answer...
How do you call the person who is inside?
By ringing the bell.
You call the person who is inside, who is out?
My lord, at the time of voting, yes, they must be inside. So how do you make them inside at the time of voting?
You call them from outside.
By ringing the bell, yes.
Thank you.
And you have to ring it for some time, then they come in. And then it says, after everybody is in, you lock. And it's clear, no movement to come in or to move out. And my lords, the policy for this is clear behind it, that this is a constitutional amendment.
Now, what is the rationale in locking the doors, the windows, the ventilators, everything?
It's what I'm calling the policy. It's what I'm calling the policy behind. It is that voting is allowed, first of all. Since this voting is allowed, there is a threat that members' choices may be distorted if they are allowed to move in and out, as they may be influenced by strangers outside parliament chambers. For example, UPDF, we argued the other day, you're not supposed to go inside. But if a member moves south and someone puts him on gunpoint, go back and vote yes. So this rule prohibits that, because you are voting loud. You stand up and say yes. So, for example, if an NRM MP, they have percent, votes yes, and then it is automatic that another NRM MP may most likely vote yes. If another NRM MP moves out, she may be influenced to come and say no. So the choices may be distorted. And my lord, the rule also ensures that only members who have attended and participated in the debate vote. Because these are important decisions. Therefore, they must be followed by reasoning, not sheer applauses, aye, aye, aye. And my lord, my submission, that since the requirement to close the doors is mandatory.
That's okay. You're clear on that provision of the rules of law in your interpretation. The question is there evidence, assuming the doors were not closed, the windows were not closed, the ventilators, is there evidence that the process of voting was actually disrupted, either by UPDF or by the likes of you telling the Member of Parliament for Nakawa that what we told you the other time, waving your fingers like this? Is there such evidence?
My lords, ordinarily, I may need not to set the evidence, but in this case, I'm referring you to page 5 to 30
yes.
of the Hansard.
That is evidence.
And 5 to 33 of the. But let me start at 5 to 30.
Yes.
The speaker said, after every person had voted, and actually the numbers were not moving the way the winning side wanted it. She said,
that's what the speaker said?
I'm reading what she said.
The winning side.
Looking at the answer because...
No, don't mix up your view. When you are referring to a record, be careful because somebody might think what your personal view is actually on.
What's your plan? And now I'm quoting the speaker.
Yes.
At page 5 to 30.
Yes.
She said, there are members sitting in the lobby. Can I ask those who have already voted to give them space so that they can come and vote? And at 5 to 33, speaker said, when voting started, there were members who were stuck in the lobby, but they are here now. I asked the clerk to check whether they are all here. And then voting continued. It's clear that in the middle of voting, members came in. Members who, I don't know from where, because some...
Mr. Mabirizi, I thought you made a very good argument that the speaker rings the bell so that those who are not in the chamber may come and vote.
Now, why didn't they come in?
Listen. But when we trade words, we don't proceed. At least when you're speaking, I listen.
Thank you, my lord.
If the law said that I should seek your permission, I would have done it. But the law says I can intervene without seeking permission. That's why I don't.
I'm obliged.
Yes. You see, you argued very well that the bell is rung so that those who are outside may come in and vote. And from the record you've just read, I had not read, I'm relying on you, the speaker said, I'm paraphrasing, because of the small capacity we have, not everybody could be inside here. Now, those who have voted, give space to those who are at the lobby to come and vote. You get what I'm saying?
Yes, but my lords,
from your own record,
I rely on Article 95, sub-Article 2 of the Constitution. That the Constitution provided for that situation. If you feel that the space is not enough, the Speaker is given powers under Article 95, sub-Article 2 to move that session to another bigger place. So, the space is not an issue. And it's my submission that
if the Speaker doesn't do that, does it become inalienable?
Definitely, my lords.
Just for not,
as I said, my lords,
relocating Parliament.
At the beginning, when I was fighting for Roko Nyango, the question here is, was there compliance? We don't look at was there an effect, because when you go there, then you are defeating the rules. Was there compliance? And the Speaker is given all the opportunities under the Constitution to proceed according to the law and the rules. That's the purpose of Article 95. And my lords, when I take you to page 5234 of the Hansard, the Speaker acknowledges that actually she breached the rules. She said, ideally, I was supposed to have closed the doors under Rule 98.4. However, that exists in a situation where all the members have got seats. But in this Parliament, 150 members do not have seats. Therefore, it will not be possible to lock them out. And that's why I did not lock the doors. And what did...
Mr. Mabiri,
yes.
Is there evidence that a non-member voted?
My lords, my argument is
No. You see, when court asks you a question, you answer, and then if you want to say something.
I'm answering him. I don't need to show evidence that a non-member voted.
No, as a matter of fact.
I
you
just
have
need,
any evidence that non-members voted?
as a matter of fact, I just need to show evidence that there was no compliance with the strict rules of procedure.
You have made the point.
Yes, my lords. And my addition on this, on the speaker's statement,
Yes.
is that this speaker knew that she was acting outside the law. But this same speaker, when it comes to reading of the budget, when it comes to State of the Nation address, she moves to conference center. Why not here? So this was intended to tarnish, to make this entire process of amendment a mock, just to mock the amendment process.
But you see yourself, you say it's not a question of effect or intention. It's a question of breach. So,
thank you, my lords. So I submit that, my lords,
Yes.
under issue 7, since we have elaborately shown that there was no compliance, and relying on the authority of Oloko Nyango, buttressed by Semogerede, where you are bound by that decision, I pray that you nullify the entire act for being procedurally effective. I thank you, my lords.
Thank you so much.
Shama, before you sit down, I have an issue that lets me clarify. I put it to Mr. Bago, but avoided it. Page 5228 of the hand. Answer.
Yes, my lord.
You have read it, I can read it. The Ms. Winfred Chiza, the leader of the opposition, informed Parliament, stated that it is unfortunate that as we come here to debate, two of the honorable members of this House have been arrested as they came to cast their votes. Would we be proceeding very well, Madam? The issue of members of Parliament being arrested as they come to vote.
My lords, in my opinion, that goes to Article 1 of the Constitution. Because under Article 1, the people are sovereign. And that sovereignty is exercised through either directly or by representatives. So I would think that that goes to Article 1, and once it's contravened, that law becomes a nullity. Thank you.
Thank you so much, Mr. Mbale. Mr. Mbale, does that...
Mr. Island Friend, Mr. Biamuka, on the issue of its remedy.
My lord, I'm sorry, my lord. The journey has been long. Take some water. Do you have some water? I'm obliged. Water clears the throat. Don't you see me taking it religious? And my lords, I'm James Biamkama. On issue number 14, I'll cover aspects of that issue, and then my learned friend, Mr. Wakafuzi, will come in, mainly on the issue of costs.
Number 14.
On remedies, number 14. Just the one on remedies. On remedies, my lord. And my lords, with your guidance all this time, as the petitioners, we are coming near to the end of our journey with you and our petitions, save perhaps for the rejoinder, if any. And my lords, on that note, as a matter of good
we are sticking to the 20 minutes pleaded for by...
True enough, my lord. True enough, my lord.
Yes.
True enough, my lord. I'm already standing in it. Okay, well, way out. My lords, the matters brought by all the petitioners in their diversity in this consolidated petition are matters of law concerning the Constitution. But also, my lords, they are matters of the heart, because they concern loving our country, loving our people and fellow Ugandans, and defending our Constitution so that we do not slide back to the dark days of history from which, as a nation and a people, we have emerged. Therefore, my lords, the petitioners in this matter, all of them from different parts of Uganda and in their different capacities. One, they love their country. That's why they have petitions. Two, they cherish the Constitution, the 1995 Constitution, which is before you, my lords, for interpretation. And when they see situations as have been presented to this court in these petitions, where the Constitution is being tampered with at will, where those privileged with the power to amend it are doing it in a casual manner, where those entrusted to enforce its articles are rendering those articles mere formality. My lords, under Article 3, they are under duty to defend their Constitution. And the duty, I'm okay. I've acquired a slide to my lords, but I'll persevere. And that duty imposed upon the petitioners in Article 3 is wide-ranging. However, my lords, in this case, the petitioners have done the right thing and brought their prayers this court, because that is what the rule of law requires, because that is the right thing to do. And they make their prayers, my lord, they make their prayers. Those prayers are in the individual petitions. Each of those petitions, my lord, has a provision of prayers, and my lords, in your own time, you'll be able to read and analyze. However, collectively, my lords, it is the main prayer of the petitioners, first as a general prayer, that let our national Constitution, as the supreme law of the land, be respected and revered by all those who are empowered under its provisions, either to amend it or to enforce its provisions. That is a general prayer, my lords. But leading from that general prayer, my lords, they further pray in their petitions that their respective petitions should be allowed by this court, on the grounds that they have presented to the court. And to highlight those grounds, my lord, there are four, by way of a highlight. One, that the Impande Act in this matter, the Constitutional Amendment Act number 1 of 2018, offends the general structure, spirit, and intent of the Constitution, which was to bestow a democratic governance and provide safeguards against dictatorship and misrule. Two, second highlight of their prayer, my lords, is that the process of papeling enactment and assent to the impaned law violated various provisions of the Constitution which have been highlighted and will be put in the specific orders for declarations by this court, but as a general ground that the process, the entire process from conception, debate, enactment, and even assent to the impaned act violated provisions of the Constitution. 3, my lords, that certain provisions in the impaned act are inconsistent with and in contravention of articles of the Constitution. And finally, 4, as a general highlight, that Parliament exceeded its constitutional amendment powers in enacting certain provisions of this act. That is the general highlight, my lords, of the prayer, running through all the petitions. And those prayers, my lords, are made under Article 137, which empowers this court to interpret the Constitution and in doing so to protect this Constitution. Read together with Article 2, Clause 2, which declares that this Constitution is supreme and that any provision inconsistent with it is null and void. My lords, these are the declarations under Article 137 that we are praying this court to give us the petitioner.
You've used half of the time.
Yes, my lord.
Yes, there remains only 10. Yes, you are accommodating Mr. Rakapur.
1, that they are saying, 1, that a declaration that the act is null and void for having been passed in contravention of the following articles of the Constitution. Article 1, Clause 4, Article 8A, the Directive Principle, National Policy Number 2, Roman 1 of the Constitution. These are the Constitution. Then Article 3.2, as the violent environment inside and outside Parliament during the introduction and passage of the Act vitiated the entire process of enacting this law. 3, that the assent given to the Act by His Excellency the President offended Article 263, Clause 2, Subclause A, on Certificate of Compliance. Also that in passing provisions of the Act, under Section, we are talking under Section 2 and 8, where Parliament extended its term of office to 7 years retroactively. That this violated Articles 1, 8A, 7, 77.3, 77.4, 79.1, and 96. Also that in passing Section 6 and 10 of the Act, extending the life of the local government councils from 5 to 7 years retroactively, this offended Articles 1.
London Council of Yamokama,
My lord,
you are losing me.
Yes, my lord.
Are you addressing us on remedies, or are you addressing us on where the fault with the amendment is?
These are the declarations we are seeking, my lord.
That will make those declarations.
Yes, my lord.
But I thought you said they're already in the pleading.
They are already captured.
No. Just say, as they are pleaded.
Yes, my lord.
So these are, as my Lord, you have correctly guided me.
Yes.
I already in the individual petitions, they have been widely canvassed during our submissions.
You said annul. Now, my question is,
Yes, my Lord.
I think this question has been put before, but I want it now more particularly that we're dealing with remedies.
Yes, my Lord.
In the event, I don't know what my findings will be. In the event that I find amending certain provisions clearly offended the law, whether offended general principle or specific provisions in the Constitution, that's easy for me. Then you're saying I should vacate those. Yes. If I find some of the amendments were within the law, the question that has remained lingering, maybe I should bring it back now. Do I annul the Constitutional Amendment Act because half of the amendments offended the law, even if half of them were within the law? Do I annul the entire thing, or do I extricate? Do I say those which offend the law will be removed from the statute, and those that are within the law remain?
My Lord, that issue has arisen several times.
Yes.
But in our prayers, our first prayer is that the entire act is fatally defective.
Yeah, because in your pleadings, everything that was done was wrong.
Yes.
So I can understand what your prayer is. But at the end of the day, if I find that not everything was wrong, even if it's just one item which was right, what do I do with that one item? It goes with the rest, or can I retain? This is the question.
My Lord, that would be an alternative prayer from us. The alternative.
I don't know. Mr. Gall, I will ask you to address me on that specifically. What do I do in the event that I find, I agree with you, that ABC were wrongly amended?
My Lord, you are raising...
And then I find that EF
you are raising
were rightly amended. What do I do? Do I still throw out the entire Constitutional Amendment Act number 1 of 2018, or do I throw out those which offended, whether general principles or specific provisions in the Constitution?
My Lord,
that's really where I want. The rest, Mr. Biamukama, in your pleadings, your prayers are there.
Yes, my Lord.
But I'm only bringing a new scenario, which will depend on, because I don't know how we will find in all this. But just suppose the situation is what I've presented.
My Lord, finally it is the discretion of this honorable body.
No, what are your views?
That depends, my Lord, on whether the doctrine of severance is applicable, can be applied. But there are situations where the entire provision is so fundamentally defective, beginning with the process itself by which it was enacted, and then going into the substance itself, that there is nothing to be said. And that is our position here, my Lord.
Thank you.
My Lord, you have taken the burden from me because you have told me, my Lord, that you'll be able to read this. I pass over to Mr. Wakafu's supplement, especially on the issue of post.
Thank you. Can you tilt the microphone to the comfortable position you're in?
My Lords, I'll go straight and address you on the issue of costs. The matter that is before you for determination is a public interest matter, and it is brought by several parties, including the Uganda Law Society, including a private citizen, and including members of parliament. But, my Lords, the rules so far we have been applying regarding issues of costs, specifically the application of Section 27 the Civil Procedure Act. My lords, it is my contention that it is wrongful. It's not applicable to public interest matters. Section 27 is read together with the Crown Proceedings Act. I mean, the Civil Procedure Act, the Crown Proceedings Act, specifically was supposed to enforce only private rights. The Crown Proceedings Act against the Attorney General clearly says you can sue the Attorney General in matters of contract, tort, breach of trust, and that kind of thing. But when we got our own...
You said we read the section 27 of the CPA with what? Together with what?
Crown Proceedings, did you say?
Together with the Crown Proceedings Act.
Crown Proceedings.
Which became, of 1959, my lords, which became the Government Proceedings Act. Yes. I'm sorry, my lords.
Oh, you're asking us to trace the roots
yes, my lords,
of the Civil Procedure Act?
Yes, 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 my lords.
Because when you were saying we read, I thought you were saying the Crown Proceedings Act apply here. That was my understanding at first.
No, my lord, it does not apply.
Oh, you want us to understand the genesis?
Yes, my lord.
Okay. So the law as it is.
When we got our own Constitution in 1962, it was incumbent upon Parliament to make rules, to make laws for the enforcement of the Constitution, specifically on the Bill of Rights and the enforcement of public rights. Of course, it did not happen. We continued applying the same rules of private rights in litigating public rights. So that's why our jurisprudence has not grown in terms of what should happen when you are litigating public rights as it is for you today, my lords. So, my lords,
I think court has pronounced itself a number of decisions in respect of courts, quite a number.
Yes, my lords, but you see, they always cite Section 27. You see, Section 27, the import of it is that the winner takes it all. But my lords, in these matters of enforcement of public...
Section 27 says the award of courts is the discretion of courts.
Yes.
But courts must ordinarily follow the event.
Yes, my lords.
The event that court is inclined not to grant costs, it must give reasons why.
Yes, my lords.
That's all.
Yes, my lords.
The courts have voted judges who have declined award costs without giving reasons.
Yes, my lords.
It's a discretion. So the general rule is that costs follow the event.
Yes, my lords.
But the principle is that the court has the discretion. That's the law of the not just the principle. That
yes.
The court has discretion.
Yes, my lords.
But when it decides to not to follow the general rule, it must give reasons why not. And it did so in the case of Bufuga Chidibata Ceremony Group, or the UN Museveni and Elizabeth cases, and quite a host of other public interest cases. There was another one where it was expounded something natural resources versus UNRWA.
Yes, my lord. Yeah. My lord, the public interest doctrine requires that private citizens who expend resources on enforcement of the Constitution, good governance, democracy, they should be awarded costs. Because litigation costs money. And they are doing it, my lord, this is not damages, but costs. They have expended money for the public good. So, my lords, it's my prayer that in petition number 5, which has been brought by private citizens, though they are members of parliament, they have gotten lawyers, and my lord, I'm also applying for certificate for 2 counsel in petition number 5.
Mr.
Then my lord,
Ladislas.
yes, my lord.
that argument of yours is double-bladed, if you understand what I'm saying.
My Lord, sir, I'm coming to that.
Yes, because you're talking long for nothing. Because if we take that as a principle,
yes,
assume you lose the petition through and through.
yes,
The London Attorney General will say, we agree with this principle, we are going to file for our bill of cost. We should be awarded cost.
No, my Lord, that would be...
It cannot operate one way.
My Lord, that's why I pointed out to you, my Lord, that Section 27 is about private rights. In this case, when you are enforcing the public good, my Lord, see, the Attorney General is in this court as a party because he's the reference for the public good. And it would
then your argument would be,
yes,
in the event, you could even say the unlikely event if you want.
yes,
In the unlikely event that this court dismisses the petitions,
yes,
cost should not be awarded to the Attorney General because of the reasons we're now advancing.
yes, my Lord,
This is
I was coming to
public
that.
interest litigation.
Most
But that is a different plane you're arguing now. You're saying because we are pursuing the interest which is not ours for all Ugandans, we are dipping our hands in our pockets. We have not gone to Ugandans to raise funds. We are doing it. So if court pleases, if it pleases court, at the end of the process, we should be awarded because this is your argument.
it is my
And I'm saying the Attorney General would also say the same. What is good for the goose is supposed to be good for the other bad thing, Uganda.
Yeah, my Lord, as I have already put it,
Yes.
I'm grateful for guiding me, but I was also coming to that point that I was arguing in case we have won the petitioners. But my lords,
In the likely event that you win,
my lords, in the unlikely event, my lords, in the unlikely event
that you lose,
that we lose, my lords, you should find that this petition was not frivolous, it was not vexatious, it was something very serious, and you could still award us costs. Yes, my lords. You see, the question of public interest doctrine invites courts to do it that way, to encourage as many people to participate in the governance of the country.
Mr. Wakafu, I don't know if court can award costs to
the losing party, my lord.
No.
Yeah.
On grounds of not vexatious, not. I think the authorities.
Yes, my lord.
There must be something done by the other side, despite winning. There must be substantial something which is
Again, my lord. Again,
so
my
that
lord.
you say this person came to court, although they have lost. It is the act of this person that necessitated thing, and the case might have failed on other reasons. Something
my lord,
like
that
this.
is
I don't know if I put it clear.
That is correct, my lord.
Yes.
And it is in several authorities. But you see, what I'm trying to say here, my lord, is that
Yes, because I understand you very well. The issue here is how that has been abused, because there was a public interest case where the court awarded 13 billion and it created wave shocks in public.
it was never paid, my lord.
No, the matter is still going on. The matter is still going on. The bill is still being taxed. So we have to have safeguards and balance. And the decision in the other constitutional matter is cited. I don't remember the long NGO part.
Yes, my lord.
We said the parties can be given nominal costs, special professional fees, but they may be paid reimbursement. They may be reimbursed.
That is the prayer of the Uganda Law Society, my lord.
Yes, the cost can be reimbursed. But for council's fees, we can give them something, because somebody gave them 20 billion. And it really was ordering abuse of court process.
Yeah, if that man, my lord, we would agree that would be an abuse of the court process. Yes, my lord.
If you say that is the prayer of Uganda Law Society, I understood the Council Wandera of Uganda to be saying You and Mr. Biamokama will address us on the issue of remedies.
Yes, my
And
lord.
remedies cuts across every petition.
Yes, my lord.
Assault.
Yes, my lord. Yes.
And we gave the time, we take it up after you, no other person is submitted. So it's not about Uganda Law Society. So that is my understanding.
No.
So you are saying disbursements and reasonable cost.
For
For all of you.
for the Uganda Law Society.
What about?
And for the proper Prosper Singh petition, for the Honorable Kafureka petition, and for Abaine Brejea petition, my lords, we pray that in case we are successful, court awards costs to council.
You are asking for a rule which applies to everybody on the side of the petition. That's so?
And for Mabilizi, my lords, I see.
The only, assuming, let me make it easy for you. Mr. Rakafuzi,
Yes.
let me make it easy for you, for Mr. Mabirizi, so that he doesn't have to talk about it. In the event that he succeeds and we were to award cost, he will not get instruction fee because he don't instruct. You get what I'm saying?
Most of that.
Yes, because professionally we cannot give instruction. But disbursement, if we are pleased to grant that, we would order for disbursement, whether the whole
Most of
I
that.
applied for general damages
No, just a moment.
and interest.
No, just a moment.
1 minute just to give you some authorities which can help on this point of course. My Lord, Justice Kakura has mentioned the authorities on public interest litigation and cost and affairs. But there is the Supreme Court decision made in 2017 in Muwanga Kivumbi versus Attorney General. I have listed it in the authorities for number 10. Muwanga Kivumbi versus Attorney General, Constitutional Appeal number 6 of 2011 Supreme Court, canvasses the issue of costs in public.
Is it contained in your
Yes, my
bundle
Lord.
of authorities?
Okay. It is at page 189 and it canvasses all these fears, but finally emerges with a guideline on costs. That this court
So let's conclude this thing of remedies. I think it's come out clear.
my Lord. Yes, I'm obliged to my Lord.
Thank you.
My lords have one authority to put your attention to. It's doctors, it is the South African authority. It's at my index 368. It is Doctors for Life International versus the Speaker of National Assembly. In that decision, Ngobo J, simple passage, he said the applicant has asked for costs. The respondents have taken the view that an order for costs is not warranted in these proceedings. In my view, that order is warranted in this case. The applicant has argued in this court constitutional issues of great moment. These issues, the applicant has been successful in that regard. The general is that cost before the event, the result must be applied in this case. So, my lords, the import is.
So we have understood.
Thank you, my lords.
Yeah, we have
My lords,
understood.
again, I applied for general damages and interest under my paragraph 3, 4, and 5.
On what? General damages and interest on general damages.
And costs.
On what?
My lords, when you read my paragraph 4, Theresa paragraph 4, these issues, they have disturbed us. They have caused us anguish.
You almost suffered a cardiac arrest.
Yes, when they were arrested. And my lord, on my side, I'm a business person. I've spent so much time and resources on this. I'm now in Mbale for almost 2 weeks. My business is rumble.
Your business is going to have a boost. You have had 2 weeks of free advance.
Advertising my business.
Okay, thank you, Mr. Mabirizi. You have understood.
I'm sorry.
Elias,
Yes,
on the list of authorities, that one is number 1. On the bundle, the list of authorities.
Is in
The
my
South African case.
is my index 368. I think.
Doctors for Life.
For life, it is in bundle E, the yellow one. So far, number 3.
I think you have referred to it.
Yes.
Several times, yeah.
Yes. My lord Kasule had a question.
Yes, and it is to you, Mr. Mavirizi, but even to Councillor Kapuz, Councillor Bia. Can we also be addressed on the issue of costs in case you lose?
My Lord, my submission is in case we lose, then each party should bear its own costs. Why? Because we are raising matters of general importance. We are raising constitutional matters. This petition has been so wide and so important that we have taken this long to finish our case. So my submission, in case we lose, but my Lord, in case we win partially, my prayer that you award us costs, because that will be a good contribution to the constitutional development of this country.
Full cost.
Yes, my Lord. Yes, my Lord.
Not partial cost.
Not partial costs. Because the Attorney General even warned the Parliament that actually we are proceeding in a red area. Thank you, my Lord.
Thank you. Yes, Elias.
Just 1 minute, my Lord, as we are rounding up this on our side, just to point out one strange fact which I invite you to put into consideration as you are evaluating the totality of evidence on record. My Lord, the fact that the key people who participated in processing this bill have not sworn any affidavit. The Right Honourable Speaker, who superintended over the process which I have submitted on this morning, the Deputy Speaker, the sponsor of the bill, Honourable Rafael Magezi, because we have spent a lot of time talking about Magezi's bill. No, I'm saying on the other side, my Lord, on the evidence, the chairperson of the Committee of Legal and Parliamentary Affairs, or both of us, the issues have come up.
The principle is that once the other party has not called the witness, you can call that witness. But put the left from him, you will not now be cancelled. Yes.
But my Lord, there was an application at the opening of the hearing, Mbale is here and others, for the Honourable Speaker to be summoned.
No,
and the issue was
issue. That's the difference. But you approach them for affidavit.
My Lord, I'm saying on the other side.
It's a principle of litigation. I've told you, learn the art of advocacy. You go there and say, Madam Speaker, we ask you for evidence. Yes. You go to Mr. Honourable Castle, since you are not called for the witness the other side, give us an evidence. In criminal law, when the prosecution has completed its case, it is supposed to give you all the statements by the other witnesses whom they interviewed, but they did not call. For you to be able to call them. So you can't complain about that.
How about in a situation where we're impeaching their own processes and they don't defend themselves? It's the point we are talking about now. This most of that man. I want to invite you to put it into consideration.
Okay, thank you. Yes, Mr. Ogalo.
My Lord,
I had asked on the other question of severance.
Yes,
and then what do you say about the flow of cost?
on the
Do we sever if we find certain provisions were wrongly amended, certain were rightly amended? Do we throw out the entire act? Do we sever? And then what do you say about cost?
My Lord, there are two ways. There are those issues which were argued, which can attack the entire process as vitiating the act. There was also, for example, an argument relying on Olokonyang that if any process of parliament is not followed, it vitiates the whole proceeding and the whole act. So my Lord, if my Lord agree with us in respect of the process vitiating the act, then the whole act must fall by the wayside. Because it is the fundament.
How about my question is, that's simple. My question is, supposing we don't agree with everything that presented,
my Lord,
only some of them.
My Lord, if you say, for example, that you rule against the process, rule against us in respect of the process, and you consider only in respect of the individual then my Lord, that was my humble submission on the authority of the moderator. You can sever.
Okay.
Yes. But my lord, I think we have made a very strong case. We have made a very strong case on the process.
I can give you the assurance. So far, both sides have made very strong cases. So how about on cost?
On cost, my lord, for my client, the Uganda Law Society, we only pay for disbursement, not for cost. But
you pay for disbursements?
Only disbursement. But as for the other, my lord, I think that people put reason as to why the cost will be granted. That, my lord, is the clause.
What do you say about Married Council legislators about the issue of certificate for two councils?
My lord, the evidence is here. Mr. Kafuzi and Mr. Rukwago, they are from different chambers. So really, the certificate for two councils would be in order.
Assuming costs are awarded.
Okay. Assuming costs are awarded.
Something on that particular issue, my lord.
On what?
On the certificate for two councils. You see, if that certificate is awarded for two councils, and you find that in one particular petition there are different law firms, my lord, for me, I look at this, not pecuniary interest as such, but these were consolidated petitions. So ordinarily, under section 27, each petition would carry its own costs.
I thought certificate for two councils is when you come from the same firm, a senior and a junior, and you say because of the nature of this matter.
No, each petition, each cost.
But when you're separate law firms, don't you file your bill, assuming you succeed and you awarded cost in your own right? You file your bill, something like that. I don't know.
What is the submission of what?
No, my lord. Initially, it was about all the petitions together. So the clarification I was making here.
The petitions I just had together, they remain separate. They remain separate.
Yes. My lord, just to clarify, in petition number 13,
Yes, Council.
we had an additional prayer.
Did you give my machine your name?
My lord is Kaganzi Lester.
Okay.
For petition number 13, we had an additional prayer for certificate of two councils. Just have formally withdrawn.
Who is the other council?
No, my client is an advocate, but we've discussed.
No, he didn't appear before us. He's here as a petitioner.
My lord, what I'm saying is I'm withdrawing the prayer for the certificate.
Of two councils. Okay. So we.
My lord, that's the clause of our submission.
We will have health break. We will. Yeah, we'll consider all this thing about certificate to council, cost or what have you. We will. So we will break until noon, health break, and then we hear from the Attorney General on his response.
Need Coca-Cola and win big. Buy any Coca-Cola product, check under the crown, and what you see is what you win. Cash, Hisense TV sets, multi-choice decoders, and much more.
Taste the feeling.
Wake up to cuddles like never before.
True love. True love.
With new Pampers Baby Dry. Their first and only diaper with 1, 2, 3 channels that help distribute wetness evenly. So it does not sag like ordinary diapers and stays drier for mornings full of cuddles. Pampers, wishing you love, sleep and play.
Send money to your loved ones in minutes from as low as 6,000 Ugandan shillings and from a network of over 500 agent locations in Uganda to almost anywhere in the world, starting at a transfer fee of Ugandan shillings 6,000. Western Union.
Teens are taking over Fanta marketing.
To make sense of the different issues here in the August House, from the different committees to the plenary sessions and the role of the MPs, we bring you the in-depth analysis of all the issues that affect the country and the policies that are made here in the Parliament of Uganda. I am Maurice Ochol, bringing you not just news, but a conversation with Uganda.
NTV, turning on your world.
Mujawali, I'm helping Ugandans make the smart choice. Why choose this powder?
It cleans just like any other ordinary detergent.
Ariel gives you better stain removal in one wash, even with less powder.
It can't be.
Observe grass, tea, and chocolate drink.
I'll need 2 handfuls.
And just 1 handful of Ariel. See? Better stain removal with only 1 wash.
It's the smart choice for sure.
Ariel removes tough stains in 1 wash.
On TV Weekend Edition, we bring you impact stories, stories of underprivileged communities, extraordinary stories of people changing lives in their communities, exclusive interviews with people in the news and Uganda's senior citizens who've made immense contribution to this country. Your health matters to us too. We got you covered in Health Focus. Ultimately, when I walk into the studio, it's not just about delivering the news. It's about a conversation that will turn on your world. Follow NTV Weekend Edition on Twitter, Facebook, and download VTV on your phones. My name is Shilan Hochri.
NTV, turning on your world.
This is my family, and I've always taken care of their skin, from their hands down to their toes. I keep their skin feeling soft, smooth, and moisturized 24 hours a day.